Paul is a professor in our department, focused primarily on research. Our students are lucky that he also teaches on our modules in multimodality in communication and on language as action. And I think he's now ready and raring to go to present his work on the language of courtroom questioning. Thank you, Paul.
In my pre-workshop talk, I focus very much on questioning in courtroom trials, looking at how lawyers ask witnesses questions. And I focused especially, or highlighted, the differences between direct examination on the one hand and cross-examination on the other. Direct examination is where the lawyer and witness are on the same side. So the lawyer is asking benign, friendly questions, questions designed to help the witness tell her story. Whilst in cross-examination, the lawyer is trying to undermine the credibility or the evidence that the witness is giving, and so it's hostile questioning. And today I want to focus very much on cross-examination, on this hostile questioning. There is a PowerPoint that accompanies this talk. I'm not going to show you the PowerPoint, it's there available for you. What I'm going to do instead is just take you through one page of a transcript from a trial for rape held in the US a few years ago. To illustrate, I'm going to show you four aspects of questioning here that are particularly prominent, and I'm going to take it from the same page. I'm not going to work through the rest of the transcript, though you have a longer extract available to you. I want to look at just four features. The first is this, that again, in that pre-workshop talk, I mentioned that there's a restricted turn-taking system, that what lawyers should do is to ask questions. There are questions and answers. Lawyers ask the questions and witnesses answer them, which gives lawyers a certain kind of power. The questioner has a power to set the agenda. This means that whatever the lawyer says should be heard as, should be done as a question. Now that isn't straightforward, that's quite a complex matter, because of course we know that in ordinary conversation, in ordinary interaction, you can ask questions which are not grammatically interrogative. You could say, you're going home tomorrow, sometimes with a certain kind of intonation, but you're going home tomorrow is grammatically a statement. It's a statement, we would call it declarative grammatically. So that you can ask questions in forms which are not interrogative forms. Now, if you look at the line 1 and 2 on this transcript, the lawyer says, now, February 14th and gives the year, you were down in the city. Is that right? Now, the first part of that, now on February 14th, you were down in the city, is a declarative, it's a statement. And the is that right is an add-on. It's like a tag question. Is that right? And then again in line 4, and you went to a bar in the city. Is that correct? So you get statements, in effect, declaratives, followed by a tag question. Tag questions of that kind put pressure on. They are inviting the recipient, the witness, to confirm. And that puts pressure on the witness or on a recipient of that kind of question to indeed confirm. So first of all, these are relatively already, they are the ways of asking a question, but in such a way as to put pressure on the recipient, on the witness. Additionally, notice that in line 10, in line 13, in line 16, and line 21, these are negative constructions. There was liquor served there, wasn't there? And you had some liquor, didn't you? The negative constructions work in our field of conversation analysis demonstrates that negative interrogatives, negative constructions are putting added pressure on the one being questioned. This is used a lot in questioning politicians, for example, and in press conferences. And it was one reason why some politicians, and I won't name names, don't care for press conferences very much. So the first feature is that tag questions, and particularly negative constructions, negative interrogatives in tag questions. Here's a second feature. I mentioned in that pre-workshop talk that the questioner has a particular kind of power, if you like, by virtue of their ability also to, they ask a question, they get an answer. In their third turn, they can, in a sense, assess, or at least imply an assessment of that answer. Now here in line 4, the questioner, the lawyer says, and you went to a bar in the city, is that correct? She answers, it's a club. Now notice that in line 8, he doesn't do a follow-up question or a next question. He does a club, which invites the other one to correct themselves. We do this in ordinary talk. The repeat or partial repeat of what someone's just said is an invitation to self-correct. And so in a way, what it's doing is to imply he doesn't believe her, or it's skeptical. It's not accepting that answer, and we'll see what happens to that later. So repeating or partial repeating by the lawyer is a way of assessing the credibility of the previous answer. Third feature is this, coming back to this bar and club. You see that when he asked, and you went to a bar, she replaces that. She doesn't say no, she doesn't use a negative, doesn't deny that, but she replaces bar with club. Now there are different connotations to those categories or words. Look though down at line 21 and 22, and you'll see the lawyer asked, it's where girls and fellas meet, isn't it? And her reply is again not no, but to replace girls and fellas with people. Now, I hardly need to go into the connotations of these, but just very briefly, of course, what she does in People Go There is to, as it were, deny the relevance of the gender in girls and fellas. And bar and club, particularly in American, bar is, of course, we know that bars are more associated with drinking than clubs. Club is slightly fancier. Let's say there's membership involved and such like. A bar highlights drinking. This witness has just attested to the fact that she was 18. In this American state, drinking at 18 is underage. The age limit is 21. So the bar already implies, but without his having to say it, that she was drinking underage. But also she's trying to go for a slightly less, one might say less sleazy kind of environment. And then finally, there's this, and it brings these things together in a way. He asked, you went to a bar. She replaced that with club. Now he pursues that. He does not allow that to stand. He pursues it in line 10. He asks, having invited her to correct in line 8, which she didn't in line 9, 1 second pause. The lawyer then says, there was liquor served there, wasn't there? And she agrees to that, yes. You had some liquor, didn't you? Yes. And 3.1 second pause, and then he hits her with, it's a singles club, isn't that what it is? That's to say, the matter of club is, whether it's a bar or a club is irrelevant. The point was, they sell liquor, yes, and you had some. It's that kind of a place. So what he does is to, in a way, undermine her attempt to replace this with a club, and to imply, in a way, that that's being evasive. And so that again, the lawyer has this power to control the agenda, to pursue a point, not to just leave it with the witness's claim, but to pursue it and bring certain bits of evidence together in a way that impugns, I think, with the witness's testimony. You have. I've given you two more pages of this transcript, and if you're working with this with students, what you can do is to first of all find the kind of those 4 things that I've been talking about. You'll find other instances, many of them, in the following two pages of transcript, and you could use it as a kind of teaching aid if you wanted to. I would say also at the end of the PowerPoint summarizes these points. At the end of that are some notes of guidance on the lead-in and other tasks that you are given. My take-home message to finish with is simply that language is essentially strategic, both the language of the lawyer, but also the defensive language of the witness. Both are involved in strategies to try to either undermine evidence or, in her case, to defend it. That's it. Thank you.
Paul, do you see any of the questioning methods that you mentioned in your analysis in the way that Keir Starmer speaks in PMQs? Adele was thinking of the way he drills down through the evidence and uses his legal background.
This is an interesting question, and it gives me an opportunity to distinguish the difference between the individual, a category of the individual, and the context in which they're speaking. I haven't actually seen much of Question Time, but of Prime Minister's Question Time. But Starmer is a trained lawyer, so his questions are forensic, as we know. But he's not speaking in a trial, in a court of law. It's rather like you as teachers, you're teachers, but you don't go home or talk to your friends in quite the same. Now, we know that there are teacherly ways, but you don't go home and have conversations which consist of you asking questions in the way that you would do with students. Similarly, Starmer is not doing it quite in a court of law, so it's a different context, even though his forensic abilities are the result of his legal training. So the point is, there's a difference between the person and the context, and we're looking at the use of language in a context. And parliamentary, although it shares some resemblance, questions and answers and so forth, it's not the same as a trial.
A related question, is language strategic in all occupations, or is it specific to the legal setting?
I was interested in that. It is, of course, it can be strategic in many settings, but it's strategic in different ways, and not quite as every question is as strategic. Let me give you an example. Just before the excerpt that I showed you, the lawyer asked the witness, and on such and such a date, you were 18. Is that right? That's to say, he asked a question. He asked for her age. Now, I've seen that question asked in health visitors. I mean, I'm working mostly on medical interaction. Health visitors will ask a parent, a mother, and then the father for their age. That is not strategic. But of course it was in the context of that trial for rape, because he was implying and setting up the matter of. So questions are not necessarily innocent. And I have done comparative work on questioning in ordinary conversation and in trials, and indeed in medical. And let's say there are different strategies.
That's great. Thank you, Paul.